This is a CBS News special report. I'm being breaking news from the Supreme Court. The court has just issued a landmark ruling on affirmative action, officially ending the practice in college admissions processes. Colleges and universities will no longer be permitted to take race into account when reviewing the college applications. Now, this is a reversal of the 2003 decision, which ruled that higher education institutions must consider race in students' admissions to promote diversity. The two cases brought before the Supreme Court by the Students for Fair Admissions argued that the decades-long practice was considered a disadvantage specifically to white and Asian American applicants. Harvard and the University of North Carolina, representing both private and public universities, say affirmative action should be upheld as their policies help ensure a diverse student body. Chief Washington correspondent, that's Major Garrett, is just outside the Supreme Court now, where we've just gotten the news. Major, all indications seem to indicate just outside the Supreme Court now, where we've just gotten the news. Major, all indications seem to indicate they were going to rule this way. Good morning to you. What are you hearing?
Good morning, Gail. Let me read directly from the opinion just released by the Supreme Court, authored by Chief Justice John Roberts. This is the most important paragraph in that very lengthy ruling. Quote, Harvard's and UNC's, meaning University of North Carolina's, admissions programs violate the Equal Protection Clause of the 14th Amendment. This opinion goes on to say, in part, eliminating racial discrimination means eliminating all of it. Essentially what the court has ruled, 6-3 in the University of North Carolina case, 6-2 in the Harvard case, because Justice Ketanji Brown Jackson recused herself because of her ties to Harvard, but 6-2, 6-3, the court has said that these admission policies, which do not include set-asides or numerical quotas, but they do consider race among many other considerations in the admissions process, is impermissible because the value of diversity, the court has argued, isn't enough to justify the harms done to other students, equally or possibly better qualified, applying to those institutions. This will have wide-ranging effects across American higher education. Many colleges across the country have been bracing for this opinion, trying to figure out how in the admissions process going forward they can create a diverse campus and collection of students in their student body, which is not only of value to incoming students, but many of their parents, without considering race. Well, the Supreme Court has now said you cannot consider race in any way, shape, or form, and if you do, you'll be violating this ruling and the U.S. Constitution. There was a case back in 2003, Grutter versus Bollinger, in which then Supreme Court Justice Sandra Day O'Connor said 25 years from now, this court rules that America will no longer need affirmative action. That case aged to 20 last week. So 5 years earlier than Sandra Day O'Connor predicted, the Supreme Court has invalidated, it appears once and for all, using race in any means whatsoever in evaluating someone's admissions to a college or university in America. Gail?
All right, Major, thank you very much. Joining us now is CBS News legal contributor, that's Jessica Levinson. Jessica, what exactly does this mean for how schools will admit students now?
So is that exactly as Major indicated, it means that you cannot explicitly use race as a factor in admissions. So we already know that colleges and universities have planned ways to essentially try to still get diverse student bodies while not explicitly using race. So we might see colleges and universities put more weight, for instance, on where did you grow up? Do your parents have graduate degrees? What zip code did you grow up in? But colleges and universities throughout the country, this applies to all private and public universities and colleges, cannot explicitly use race when they're making a decision about who to admit.
Now, we heard them say that they believe that it violated the 14th Amendment's Equal Protection Clause. Can you just sort of break it down exactly what that means, that it violated it how?
So the 14th Amendment and the Equal Protection Clause says that everybody is entitled to equal protection under the law. And we know since the drafting of the 14th Amendment, that is meant to prevent invidious racial discrimination. And the question for the court really was, can taking race into account comply with the command from the 14th Amendment that we don't discriminate on the basis of race? What does equality really mean? And today the court said, Chief Justice John Roberts, in language that absolutely echoes other lines we've heard, the way to end racial discrimination is to stop taking race into account, essentially. This is very different from the view that the liberal justices have and Justice Jackson had. and she has a lengthy dissent explaining why equal protection allows the government, allows private colleges to say, we will take race into account in order to try and get to a place of equality.
And we heard Major say that the judge, Ketanji Brown Jackson, recused herself from the Harvard case because of her ties there. So when you look at it, when you look at the big picture, who benefits and who loses here?
Well, it depends on your perspective, but affirmative action programs were implemented. Actually, the legal reason was not to try and basically right the wrongs of our society. It was not meant to try to help people who had faced systemic discrimination. The point was to help all of us by creating more racially diverse student bodies. And I think a lot of people don't realize that about affirmative action programs. It was supposed to, again, benefit white students, Hispanic students, Asian American students, Black students. So if that's your perspective, then that help is no longer there. Now, for other people, they feel affirmative action programs have hurt Caucasian applicants, have hurt Asian American applicants, and that those applicants will be helped by the ending of affirmative action. We know from prior experiences in states like California that ending affirmative action tends to dramatically decrease the number of Black and Hispanic students in certain colleges and universities.
Yeah, I think, Jessica, you set it up perfectly. Depends on your point of view, because some people will be cheering this decision. Other people will be heartbroken by the news today. Let's bring in senior White House and political correspondent Ed O'Keefe. Ed, have you heard any reaction from the White House yet? I know this is just breaking now.
It is, Gail. We have been told to anticipate some kind of a reaction, but that the White House, its lawyers, and the president would want to read through the ruling first before really weighing in. He's got some time before he heads to some events in New York around midday where we might hear from him either on paper or in person. One thing to consider, though, when it comes to the issue of affirmative action more broadly, we recently did some polling on this, Gail, and it found that 53% of Americans believe that affirmative action broadly should be continued. About 47% said it should not. But on the question of race-based college admissions, look at this, just 30% think colleges should be allowed to consider race in college admissions. 70% think they should not. So it's not that the court is necessarily taking its cues from public opinion. It says it never does that. But it does show here that the ruling today reflects broad public opinion. And that is something that, you know, obviously will be considered in the political space. But the Biden administration had argued that in the case of Harvard's admissions process, they didn't believe it was in violation of the 14th Amendment, that the policies should be allowed to stand, and that the court should allow the university to continue doing so. Obviously, they've run counter to that today, and will await a formal response from the president and his administration as to what exactly it believes. One other thing to call out here, in the ruling itself, towards the bottom of the Chief Justice's opinion, he writes in part, quote, "Nothing prohibits universities from considering an applicant's discussion of how race affected the applicant's life, so long as that discussion is concretely tied to a quality of character or unique ability that the particular applicant can contribute to the university." We had anticipated there might be something like this that would say you can talk about it in your college essay, or it can be taken as part of a broad spectrum of reasons why you should be admitted. But the idea that a university is going to look explicitly at one's race alongside other factors is what the court today is saying is not allowed.
That sentence you just read is very interesting inclusion in this ruling today. You know, when you look at the big picture, how do you think this will impact the number or percentage of minorities who get accepted into universities? When you look at it on its face, you think, how will it not? How can this possibly not affect Black and brown students here?
Yeah, look, there is some evidence that in recent years, as college admissions processes regarding race changed, there was a lower number of minority applicants accepted. Perhaps that is inevitable. And so that's obviously where a lot of proponents of what UNC and Harvard were doing are going to be concerned, that this could adversely affect the admission of Black, Latino, Asian American students. But the other thing to remember here is back in 2003, then Justice Sandra Day O'Connor had warned that given the way society was changing and given the contours of affirmative action, she believed that at some point in the next 25 years, this ability for colleges to consider race so explicitly was going to get struck down. Now, almost 20 years later, it appears that has happened.
Thank you very much, Ed. Chief Washington correspondent Major Garrett, we're going to go back to him outside the U.S. Supreme Court. I wonder if we could follow up on what Ed was just saying.
Yes.
Major, I read recently between 6 or 7 students who had decided, 6 or 7 states rather, who had eliminated accepting students based on race, that there had been a significant increase in the acceptance of black and brown students.
Right. Let's go over the specifics on this, Gail, because this was argued before the Supreme Court. It was part of the briefs the courts considered. 8 states in the United States, and I'll list them off to you: California, Florida, Michigan, Nebraska, Arizona, New Hampshire, Oklahoma, and Idaho have banned using race as a factor in college admissions. California was the first. It did that by referendum. What has been California's lived experience since then? And this was briefed to the court. In the UC system, University of California system, its most selective schools, it saw a 50% drop almost immediately in admissions for black and Latino students. And the University of California system has tried to figure out a way to increase those numbers after taking race out of the consideration process. It has been unable to find a formula, a holistic formula, a non-formulaic formula. That's some of the terminology presented to the court to raise those numbers. So it had an immediate effect, and it has not rebounded since. And that is something that was briefed to the court, that there are real-world examples where if you take race out of the equation in any way, shape, or form, it is very hard to reach these goals of diversity that colleges, either private or public, have set for themselves. And as I mentioned earlier, and this has become a part of the conversation, it's going to be an ongoing part of the conversation, students coming to college want a more diverse campus body to go into. Their parents oftentimes prize that. How do you get there? What are the methodologies? That's going to be something colleges now are going to have to work out. And the experience in California is instructive. And those who represent and speak on behalf of African American and Latino students say it gets ever more harder once you take race out of the consideration process entirely. Well, that may be the result for those states in the country, unlike the 8 that have already banned it, that haven't done so now, because they're going to be reconciling those different difficulties and the challenges presented by creating a diverse student body on college campuses without taking, at any shape or form, race into consideration. Gail?
Major, thank you very, very much. It'll be interesting to see how going forward universities will make an effort to remain diverse. This is such a very important question that really affects all of us. Thank you. Once again, breaking news: the Supreme Court ends affirmative action in college admissions. Our coverage will continue on CBS News Streaming, your local news, and of course tonight on the CBS Evening News with Norah O'Donnell. This has been a CBS News Special Report. I'm Gail King, here in New York.